my name is Lauren. I'm the owner of Canine Refined. I'm a qualified assistance dog trainer and I'm currently studying criminology and criminal justice at university. Today I'm going to be talking about the minimum standards an assistance dog must meet to have public access rights. The information in this video is compiled from multiple sources which are listed in the description. The Disability Discrimination Act, also called the DDA, is quite vague, especially when it comes to Section 9C. To provide clarity, I've researched court cases, international assistance dog standards, state legislation, and standards from organisations that are accredited under Section 9A. This video represents my interpretation of the law as someone who has experience in both assistance dog training and the legal system. If you find this video helpful, please feel free to follow me on social media. Section 9C of the DDA defines an assistance dog as an animal trained to assist a person with a disability, to alleviate the effects of the disability, and to meet the standards of hygiene and behaviour that are appropriate for an animal in a public place. Let's break this down into three parts so it's easier to understand. 1. Trained to assist a person with a disability. 2. The standards of hygiene. And 3. Standards of behaviour. So first off, we have trained to assist a person with a disability. Research indicates that this means the dog is able to perform tasks directly related to a handler's disability. Examples include guiding, medical alert, item retrieval, deep pressure therapy, and much more. These tasks must be specific to a handler's disability. For example, if an assistance dog is trained for a hearing-related task, but the handler has perfect hearing, the dog likely doesn't meet the criteria for assisting their disability. It's also important to note that a dog simply being with a handler doesn't qualify as trained to alleviate the effects of a disability. Emotional support alone is not recognised under any state or territory laws. Instead, the dog must perform physical tasks, whether alerting to a medical condition or interrupting harmful behaviours. Most sources suggest that a minimum of 3 tasks is standard. I also want to note that there has been alleged court cases against dogs who have had emotional support as a task. I was unable to find any of these, and so I couldn't read them or cite them in the comments, but there has been no proof that I've seen in any of the court cases I've read or any of the state legislation that suggests that emotional support is considered trained to alleviate the effects of a disability. More often than not, task trained is specifically mentioned, even though it's not mentioned in the Disability Discrimination Act itself. The next thing we have is standards of hygiene. Hygiene is largely common sense, but it is also clearly defined in many official bodies. Maintaining hygiene standards means practices that prevent disease and ensure cleanliness. Consistently, the standards I found include the dog is clean, well-groomed and free of offensive odours. So basically, you regularly clean your dog and it doesn't smell, in layman's terms. The dog does not urinate or defecate in inappropriate locations and is trained to do so on command. So your dog is trained to have a go to the toilet cue before you enter the shops to ensure that there are no accidents. The dog is treated for worms, fleas and other parasites. The dog is not sick or at risk of carrying disease. And this primarily is flea, tick and worming your dog monthly, and also receiving vaccinations, or some people would argue that titer testing is also a valid substitute. Essentially, if your dog has the antibodies to protect itself from getting diseases, then that's okay. And titer testing, I don't know too much about it, but I believe that it tests for antibodies of diseases that people would normally vaccinate against. So in summary, the standards of hygiene, pretty much your dog just needs to be clean, it needs to go to the toilet on command and not in the shops, and it needs to be appropriately protected against parasites, diseases, fleas, ticks, all that sort of thing. Finally, we have standards of behaviour. This area can be trickier to grasp because although it's a lot to do with common sense, it's also variable in practice. The best guidance when it comes to standards of behaviour come from public access tests and legal disputes. Behavioural standards include: the dog does not solicit attention, visit or annoy members of the public. The dog does not disrupt the normal course of business. The dog does not vocalize unnecessarily. This includes barking, growling, or whining. The dog shows no aggression towards people or other animals. The dog does not steal or solicit food or items from the public. The dog works calmly and quietly on a harness, leash, or other tether. The dog walks in a heel position and stays out of the way unless performing a task such as guiding. The dog remains under tables and chairs in busy environments. The dog can lie quietly beside the handler without blocking aisles or doorways. The dog does not go on public furniture. The dog remains calm in confined, crowded, and noisy situations. The dog does not react disruptively to other animals. These standards ensure that the dog is not only effective in assisting the handler, but is also safe and respectful in public places. I think it's also important to note that people will train their dogs to bark as an alert. More often than not, this is an escalation from the dog trying to paw you or boop you when you're having a medical episode or about to have a medical episode. And if you ignore the dog, sometimes they will bark at you. And there wasn't any resources I could find specifically stating whether that was okay or not, but in my personal opinion, I think that if it is a last resort, your dog barking at you would be acceptable in public. But a dog barking at another dog or at people or at sounds, that would not be appropriate. Essentially, a really good way to get a grasp on understanding whether your dog meets the standards of behaviour and hygiene to be in a public place is to talk to a trainer or just talk to anyone in the assistance dog community. A lot of us have a really good grasp about what this means. The purpose of this video was more so to compile sources that you can read as well, which will be in the description. But in general, asking people whether they think your dog meets the standards under Section 9C of the DDA is helpful. But obviously, consulting a trainer is probably the best way to go if you're unsure. For example, people who do my program, I will assess them in a pet-friendly situation before suggesting they do public access, because you shouldn't jump straight into public access, and you can't with a puppy. Puppies doing public access is a tricky topic. A lot of people will say that under Section 9C you can take your dogs into public when they're a puppy if you have permission from the owner of the building. And I don't entirely agree with this. There is nothing in Section 9C of the DDA that suggests that a puppy can do public access. They're not task trained at that point, they're not trained to heel, they probably don't have solid obedience, they definitely don't have solid toilet training. There's a bunch of things going on which lead me to think that there isn't a way that a puppy under 6 months would be able to meet the definition of an assistance dog under Section 9C. However, under Section 9A, some organisations that are accredited do take puppies into public access. And that's not because they're disobeying the law, that's because under Section 9A, it mentions state and territory laws. For example, GHAD, Guide Hearing Assistance Dogs, which is the Queensland legislation, they can take puppies out into public access. So GHAD, for example, explicitly states in Section 9 of the Act, trainers and puppy carers may be accompanied by guide, hearing and assistance dog and trainee support dogs. It says, despite any act, an approved trainer, employee trainer or puppy carer may be accompanied by a guide, hearing or trainee support dog in a place of accommodation, public place or passenger vehicles. That is written a bit oddly, but essentially the people who are accredited as trainers or organisations under GHAD are allowed to take their puppies into public, but you, as an owner trainer under Section 9C of the DDA, are not. Even if you are working with an organisation, if that organisation is not accredited by a state that has legislations that says that you can take your puppy into public access, then you can't do that. But most people in Australia work under Section 9C, so it's not entirely relevant unless you are a trainer that is accredited by one of these states. For example, just because an organisation is approved under Section 9A doesn't mean that they can take puppies into public. For example, I am an ACT approved trainer and assessor, but there is nothing that I can find in the legislation for the Australian Capital Territory which specifically states that I can bring a puppy into public. So it definitely depends on the state you're in, but again, it's not really relevant to most people with assistance dogs, as most people are operating under Section 9C. That's it for today. I hope this video clarifies the minimum standards for assistance dogs in a public setting. If you have any questions or found this helpful, please feel free to follow me on social media. Check the description for additional resources, and feel free to comment or message me any further questions you have or anything you need clarity on. Thank you so much for watching.